more family out
Oh,
there?
I don't think so.
Oh, I thought you said you saw
Do a
people.
double check. Morning.
Oh no, I was talking about if they sent me a picture. Yeah. Thank you though. Appreciate it.
Call prospective jurors over there.
Thank you.
All right, no problem.
Do something else. Lies.
Now we're here at case 23CR000002, State of Ohio versus Jacob Grulaski. We're here on a motion to terminate community control sanctions that was filed by the State of Ohio. Defendants previously waived probable cause hearing, and we are here for the final hearing. He is in court, represented by Counsel Nicole Novotny. Ms. Novotny, what is the defendant's intention at this time regarding the final hearing?
Your Honor, with my client's intention with the final hearing is to waive the final hearing at this time in the midst of the violations, Your Honor.
Thank you. Mr. Garlaski, you have been charged with violating the conditions of your community control sanctions. Specifically, it's alleged you violated two separate rules. The first is Rule 10, which requires you to submit random urine screens as directed by your probation officer. You're not to alter or tamper with the urine screen, and you should not have in your possession any device or substance to simulate a urine sample, nor bring with you a urine sample. And it's alleged that on August 6th, you reported to the Lake County Adult Probation Department for a random urine screen, and you were found to be in possession of fake urine. It's also alleged you violated Rule 8, which prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. And it's alleged that you submitted a urine screen on that day that tested positive for cocaine, and that you acknowledged that you used cocaine a couple days earlier. Now, you have the right to have a final hearing regarding these allegations, and that's a hearing where the state would be required to present evidence to prove the actual merits of what they're alleging. Now, you could have you can have this hearing, but you can also waive the hearing if you desire and plead guilty to the violation. Your attorney has indicated she believes that's what you want to do, is waive the hearing and plead guilty. Is that correct?
Yes.
Well, before I can accept your waiver and your plea, I need to make sure you understand the potential consequences you face if you are found to be in violation of your community control sanctions. If, in fact, that did occur, the court could extend your probation up to a total of 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it could be 36 months on count 1, and 12 months on counts 4 and 7. Those can all be ordered to be served consecutive for a total of 5 years in prison. So do you understand the potential penalties you face if you're found to have violated your community control sanctions?
Yes, sir.
Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing, or do you want to waive the hearing and plead guilty to the violations?
I'll waive the hearing and plead guilty, Your Honor.
Very well, then, as to the allegation that you violated Rule 10 by bringing in fake urine to the probation department and one of your reporting dates, what is your plea to that?
Guilty.
As to the allegation you violated Rule 8 by using cocaine, what is your plea to that?
Guilty.
All right, the court will accept your plea of guilty, find that you did violate your community control sanctions. Ms. Novotny, any reason not to go forward with sentencing?
We may go forward, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. With regard to the incident matter for the probation violations, we would ask the court to consider continuing Mr. Grulowski's community control. I know our office submitted a letter with regard to our current situation. I know with regard to this current situation, he has an application that's pending with Ohio Medicaid due to the situation with him being laid off from his job. We are waiting an approval once documentation has been received to verify his prior employment to show that he's within a threshold that he can qualify for Medicaid. Upon receiving a notice for Medicaid, there have been 2 places that he has been referred to that would be able to accept him upon his insurance being fixed. One of those places is Stella Maris, Your Honor. The other one is the Surgent. Both these places sound promising for Mr. Grulowski. I know he wants to continue with his treatment with regard to his relapse. I know a big issue with his relapse was that he was laid off from his job at Royal Plastics that he's had for a little over 8 months. Your Honor, I know that was causing him a lot of stress. Before his incarceration, he was applying to 12 to 15 jobs in order to fix that situation. I know it became very stressful for him, which ultimately caused his relapse and why he's here in front of you today. Prior to that, Your Honor, he was going to Lake Geauga for 2 years. He was doing 3 AAs a week, and he obtained a sponsor and was seeking help for that sponsor as well. We're just asking for any type of leniency with regard to this instant matter in front of you today. I would ask the court to continue with his community control at this time. Thank you.
Thank you. Mr. Gorlowski, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor. I just wanted to say I know that I've made mistakes, and I was doing really well for a while, and I unexpectedly lost my job because they laid me off. They lost like 50% of their orders because of the Chinese tariffs. So I didn't see that coming, and it was hard for me. And then trying to apply back to get another job was another struggle for me. And I got weighed down by the bearings of trying to find employment and trying to continue moving forward in my life. And I made bad decisions and went around people, places, and things that I shouldn't have. And that led back to me using again, which is unfortunate. But I want to continue my treatment, and I want to prove to my family and to myself that I can do better and that I can live a sober life and be successful and be happy and proud of myself. That's all, Your Honor.
Thank you. Ms. Novotny, anything else?
No, Your Honor.
This court has reviewed the pre-sentence report and investigation that was originally prepared. Drug and alcohol evaluation. I've considered the facts and circumstances of the original underlying offenses, the nature of those. I've considered the defendant's performance on probation, the nature of the violations. I received a letter from the Public Defender's Office. I've considered that. I've considered what's been said here today by the defendant and his lawyer. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-2911. As for the factors in 29-2912, I will incorporate all the findings I made at the original sentencing hearing regarding the seriousness factors and the recidivism factors, with the additional finding today that the defendant has again failed to comply with the previously imposed sanctions ordered by this court, which is a factor indicating recidivism is more likely. At this point, where the defendant's previously violated his probation, I gave him another chance then. We've given him every resource we have at our disposal here. He's done jail treatment program, he's done NeoCamp, he's done Lake House. He's done all the treatment programs we have. Still used, and then he brought fake urine in and tried to perpetrate a fraud upon the court and the probation department. At this point, there's no way this court can make a finding that the defendant's amenable to community control sanctions. Prison is consistent with the purposes and principles of sentencing. Therefore, it will be the sentence to this court that on count 1, defendant served a term in prison of 18 months. On counts 4 and 7, served a term in prison of 11 months. I'll run those counts all concurrent with each other for a total of 18 months. He does get credit for 282 days that he's already served. I need to advise you, upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term imposed by the court, and the additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. The defendant's ordered to pay all costs. Is there anything else for the record, Ms. Novotny?
No, Your Honor.
All rise.
Good morning.
Morning, Your Honor.
We are hearing case 96 CR 241. It was captioned State of Ohio versus Carrie Shower. You now go by Carrie Taylor?
Yes.
Is that correct? Okay. Ms. Taylor's here on a motion requesting expungement and sealing of record regarding this case. The court received the request, referred this matter to the probation department so they can prepare an investigation into her eligibility. That has been prepared, provided to counsel for the state, and the matter has been scheduled for a hearing, as we never heard back from the state regarding this. So Ms. Taylor is here, and the state of Ohio is represented by Assistant Prosecuting Attorney Rocco DePiro. So Ms. Taylor, I'll let you be heard on your request at this time. Is there anything you'd like to say? I mean, I read your letter, but you have an opportunity to say whatever it is you'd like me to know in regards to this request.
This has been so long ago, I just trying to clean up, it's been hanging over my head all these years, and I just thought it was time to clean up my past and let it go, and hopefully. So
is Taylor because you're married, or?
Yes.
Okay. How long have you been married?
I got married 2003,
okay,
October
nice.
4th, so we're coming up on 22 years.
Good for you guys. It's nice. And you work in with a vet or with grooming pets or hospital?
Yes, I'm a dog groomer. I've been grooming for 28 years, and I work at the animal hospital. I've been there for 6 years now.
Okay.
And I work at home. I help people in the neighborhood that kind of can't afford to take their dogs, or they don't have the vaccinations requirements for other places, so I groom them at home.
Okay. Okay. Anything else you'd like me to know? You don't have to. I just want to make sure you've had an opportunity to say
I think so.
whatever.
I'm just trying to be a different person, not, just trying to clean
I
up.
saw that there was a couple issues, not recently, it was still 6 years ago, with the OVIs that 1 year, 19.
Right. Yeah, I've been sober since that.
So 6 years, 5, 6 years?
Yep, I'm just trying, it's part of the process, cleaning up your mess in the past and
Okay.
move on.
So all that's over with, and there's nothing pending from that in terms of any
Nope,
being on probation for that or anything like that?
nope.
Okay.
Mm-mm.
All right. Well, thank you. Mr. DePiro for the state of Ohio?
Thank you, Your Honor. We did notify the Mentor Walmart, the victim in this case, about this hearing. Spoke with the number 2 in charge of the store, who said he believes everybody should get a second chance.
Oh.
So the state does not object to the motion to seal.
No, she's requesting expungement and sealing.
Oh, okay.
So, all right, well, I've reviewed the report from the probation department. I've reviewed the original file that was we have in this case from 30 years ago. Listen to what Ms. Taylor's had to say here, the prosecutor's position. And considering all of that, the court finds the motions well taken, so I'm going to grant your request for the expungement and the sealing of the record. So we'll do an entry granting this within the next week.
All right,
It'll
thank
be
you so
done.
much.
Now I have for you, we'll send this to you, so make sure we have the right contact information and address of we don't need Control Sanctions, defendants in court, with counsel Mr. Timothy Deeb, states represented by Assistant Prosecuting Attorney Sarah Haranek. Are both sides prepared to proceed? Mr. Deeb?
Yes, Your Honor.
Ms. Haranek?
Yes, Your Honor.
All right, then you may call your first. Well, first I'm going to order a separation of witnesses. If there's anyone in the courtroom who's going to testify at this hearing, you need to remove yourself at this point. I'll ask the attorneys to help monitor that because I don't know who the witnesses are or not. All right, state may call its first witness.
Thank you, Your Honor. The state calls Kaylee Warren.
Stop you there and have you raise your right hand. You swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth.
I do.
All right, have a seat. Ms. Haranek, whenever you are set.
Thank you, Your Honor. Good morning. Can you please state your name and spell your last name for the record?
Kaylee Warren, Warren.
Where are you employed?
Lake County Adult Probation.
How long have you been employed there?
About 5 years.
What is your position with the Lake County Adult Probation Department?
I'm a probation officer.
And what are your duties as a probation officer?
I monitor offenders that are on medium to low supervision. I also am a lab tech at our urine lab.
And are you familiar with the defendant, Daryl Odom?
Yes.
How are you familiar with him?
He was assigned to me on January 27th of 2025.
Do you see Mr. Odom in the courtroom today?
I do.
Can you please specify where he is seated and what he's wearing?
He is seated at the defendant's table. He has a blue jumpsuit on.
Honor, let the record reflect that the witness is identified the defendant.
Record may so reflect.
Thank you, Your Honor. You stated that Mr. Odom was assigned to you so he is on probation and you are his probation officer as of January of 2025?
Yes.
Okay. And when was Mr. Odom originally put on probation for this case?
He was placed on probation on January 5th of 2024.
So are you his only probation officer on this case?
No.
Is there somebody else who is a probation officer before you?
Yes.
Okay. What is the procedure when a person is put onto probation with the Lake County Adult Probation? How is that initiated?
They're placed with the correct officer. It depends on where they're living at in the county. They're given that officer, and then they meet with the officer, and they're placed on the rules of probation.
And what are the rules of probation?
The rules of probation are a list of rules that need to be followed while you're on probation. He signed them on January 9th of 2024.
And so he's advised of those rules. Is he given the rules in writing?
Yes, he's given the rules. Each rule is signed, or each rule is read to him, explained, and then he initials next to each rule. At the end, he will sign and date next to the probation officer's signature and date.
In addition to the rules of probation, does Mr. Odom have any specific probationary rules that were put into place by the court?
Yes.
What were those? Well, let me be specific. Was one of the rules that the court imposed that the defendant be subjected to random drug screens?
Yes.
And he was ordered to have complete abstinence from drugs?
Yes.
Thank you. How many rules are there, probationary rules, that the defendants are read and acknowledge?
There's a total of 12 rules.
Okay.
There's technically 13, but the 13th one is just saying what your release date is.
Okay. Specifically, what is rule number 8?
Rule number 8 reads, you shall not use, possess, or have on your control any controlled substance not prescribed to you by a licensed physician. Use of alcohol is prohibited.
Is there also a rule that has to do with having contact with other police departments, police agencies?
Yes, there is.
Which rule is that?
That would be rule number 1 and rule number 2.
How is that monitored by the probation officer?
We can run leads. We can run those whenever. I heard it from Darrell. He's the one who reported to me that he had police contact.
Okay, so let's, I guess, start there. So at some point during your supervision of the defendant, you were made aware that he had interaction with the police department.
Yes.
How were you made aware of that?
Darrell called me himself on May 5th.
And what did he tell you?
He told me that he was arrested for an OVI. That was what the voicemail said.
Did he tell you where he was arrested?
When I called him back, he did say,
And where was he arrested?
Walton Hills Police Department.
Once you got that information from him, what did you do?
I requested the police report.
Okay. And did you receive that police report from the Walton Hills Police Department?
I did.
Okay. And based on that police report, did you have any contact with the arresting officer?
I did. I spoke with the arresting officer.
And based on the police report and your conversation with the arresting officer, did you feel that the defendant had violated any of the rules of probation?
Yes.
Which rules?
Rule number 1. And then also rule number 8.
And what were the violations for rule number 8 that you had reason to believe after speaking with the officer?
Based off of the police report and speaking with the officer, I found him to be in violation of rule number 8 for possession of marijuana, and he also smelled of alcoholic odor during his arrest.
Is use of alcohol prohibited as part of the rules of probation?
Yes, that's rule number 8.
I'm going to interrupt you for 1 minute just to put on the record. While the defendant was charged initially with a Rule 1 violation for purposes of this hearing, we're not going to proceed on that in as much as those charges are still pending. We're just going to proceed on the other 2 from the first violation and the Rule 8 violation from July.
Thank you, Your Honor.
I mean, obviously, if you have to reference that in any way, I understand that, but in terms of actual adjudication of that rule, we're not going to address that. I'm not going to put the defendant in any position to have to address that.
Thank you, Your Honor. So after receiving this police report and speaking with the arresting officer, did you file probation violations against the defendant?
Yes.
For these rule number 8 violations?
Yes.
Okay. The defendant, as you already testified, is already ordered as part of his probation to submit to random drug screens. Is that correct?
Yes.
What is the procedure for collecting drug screens of someone while they're on probation?
We start by printing out a sticker. We have a database. It's called Paracelsus. Every offender is in there. They have their own accession number. They have their own ID number in there. We go to the computer. We print out a barcode, prints out 2 different stickers of the same exact barcode. I grab a sterile urine cup. I place 1 sticker of the barcode onto the cup. I have the defendant confirm that it is him by verifying his birthday. They go into the bathroom, provide the sample inside of the cup, come back out of the bathroom. They put their initials on the lid. I seal the lid, and then I place it into the refrigerator in its own specific spot.
And then those samples are run within a lab in the probation department?
Yes.
Okay. How often are these random screens conducted?
It's hard to say. It depends on the defendant. It depends on the charge. There's a lot of different factors that go into it. At the time, Mr. Odom was being screened basically weekly. I think there was 1 or 2 times while he was out on bond that I did not grab a screen, but he was being screened very frequently at that time.
And when did those screens begin?
He was released from the jail on June 10th, so it was somewhere around that date. I don't have the exact date of his first screen around that time.
Okay, but basically once he was released from the jail, you began collecting these about weekly random drug screens from him?
Yes.
Okay. Is the defendant made aware that a screen is going to be happening prior to the day that they come in to submit the screen?
No, I don't, personally.
Okay. So turning your attention to July 28th of 2025, was the defendant given a random drug screen on that date?
Yes.
Okay, and what did you use the same procedure that you just described?
Yes.
In collecting that screen?
Yes.
And then were you made aware of the results of that screen?
I was.
Based on the results that you received, did you file an additional probation violation against the defendant?
Yes, I did.
And a violation for what rule?
Testing positive for marijuana. It's rule number 8.
Okay, thank you. I have no further questions, Your Honor.
Cross-examination, Mr. Deeb.
Can I just from the table?
Wherever you want. You can use the podium there if you want, or pretty informal.
Thank you, Judge. Kayla, good morning.
Good morning.
With Mr. Odom, was he always on time and showed up punctually for his appointments?
He did report when he was supposed to report, yes.
Okay. And when he was requested to take a screen, he never gave you a hard time?
Nope.
Now, we're aware that the screens that you have for marijuana have a cutoff level, correct?
Correct.
And on June 28th, he was slightly above that minimum cutoff level, is that correct?
Yeah.
In your department, does that indicate that he was around marijuana or that he ingested it?
I can't really speak to that. There's a cutoff level of 50 nanograms. He tested above that level.
And that he could get that from being around marijuana, not necessarily ingesting it if he brushed up against it, touched it? Is that possible?
I can't say with certain. I don't believe so, but I can't say yes or no.
And with the following screen, when he was arrested, because he came in the following Monday, correct?
Correct.
And you knew that you guys were going to take him into custody because of the positive screen. He was screened again, correct?
Correct.
And that screen was under the prescribed limit, correct?
It was negative.
Was he tested on July 21st?
I don't have that information right in front of me on what day he was tested. I have the test when he was positive.
Okay. You don't know if you gave him a screen the week prior to the 28th?
I'm sure that I did. I can't testify that yes, 100% I did. I'm able to look. I don't have it in front of me right this second.
But do you believe that you did test him?
I'm sure that I did.
And you don't have that result with you because if it was positive, you would have definitely pulled it out, correct?
Yes.
So it's most likely there was a negative screen on the 21st. That's the Monday's the 21st. Then the following Monday, the 28th, he got the screen, it was positive. It was tested, positive over the limit. Then the next week, he tested positive, or he still had marijuana in his system, but it was under the 50 nanogram limit, correct?
He was negative, yes.
What are typical levels for a user that you guys see in probation?
We don't go off of levels. It's either positive or a negative.
Now, with the incident in Walton Hills, have you seen firsthand any of the information that was collected by those officers, any of the evidence?
I read the police report, and I received pictures of marijuana and then the bottle of alcohol.
Okay, but you didn't go investigate any of that or anybody from your office?
No.
The only information you have is what was given in a police report and pictures sent from the police department?
Yes.
And the administrative staff?
The arresting officer.
Other than the positive marijuana screen that we have currently, since his arrest from Walton Hills, has he been complying with his probation, excluding the positive screen?
Yes.
He's been doing well?
Since I've had him, this is the first violation that I've had with him.
But he is doing well other than that.
He's been in compliance.
Thank you, Caleb.
Thank you.
Redirect examination.
I have no further questions, Your Honor.
All right, you may return. Statement call its next witness.
Thank you, Your Honor. The state calls Patrolman David Rakoff.
Sir, please raise your right hand. You swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
See. When you're set.
Thank you, Your Honor. Good morning. Can you please state your full name and spell your last name for the record?
David Raykov, Raykov.
Where are you employed?
Walton Hills Police Department,
What is your position with Walton Hills Police Department?
patrol officer,
How long have you held that position?
9 years.
I'm sorry?
9 years?
You're a certified peace officer in the state of Ohio?
I am.
Are you familiar in the course of your duties as Walton Hills Police Officer with Daryl Odom?
Yes.
How are you familiar with him?
I conducted a traffic stop, which led to an OVI arrest.
And what date did you conduct a traffic stop where you interacted with Mr. Odom?
May 2nd.
Is that of this year, 2025?
Correct.
And what led you to conduct that traffic stop?
I was running stationary radar, and I clocked him at an accelerated rated speed.
Okay. And about what time of day did this occur?
This was approximately 2:37 in the morning.
In the morning?
Yes.
So you initiated a traffic stop on the vehicle that you observed speeding.
Correct.
Did the vehicle come to a stop?
It did.
Did you make contact with the occupants of the vehicle?
I did.
How many occupants were there in the vehicle?
Just the defendant.
Just Mr. Odom?
Yes, correct.
Okay. And did you observe anything in the vehicle at the time that you made contact with the defendant?
Yes, on my initial approach, I did a passenger side approach, and on the passenger seat was a bottle of Patron.
Okay.
Bottle of what?
Patron, tequila.
Did you recognize it immediately to be a bottle of Patron
Correct.
tequila?
Yes.
And where was it?
On the passenger seat,
On the seat itself?
on the seat itself.
Just open, in the open?
Yes.
Were you able to see it in plain view upon your approach of the vehicle?
Yes.
May I approach the witness, Your Honor?
You may.
Officer, I'm handing you what's been marked as State's Exhibit 1. You recognize this?
Yes.
What is that?
As the bottle of Patron.
This is a picture
Yes.
of the bottle of Patron.
Correct.
This is the bottle that you found in the vehicle the defendant was driving?
Yes.
On the passenger seat.
Yes.
He was the only, was there anything else on the passenger seat?
No.
Just this bottle?
Correct.
Was the bottle, could
Keep
you
that
tell?
here, if you're gonna,
I'm sorry?
leave that picture. Actually, can I have it?
Yes.
Thank you.
As far as you could tell, was the bottle open?
It appeared so.
Was there, as far as you could tell, still alcohol inside the bottle?
Yes.
Was it full?
There appeared to be some missing.
Did you make any other observations of the defendant at the time of this traffic stop?
Just slurred, little mush mouth, a little slurred speech while doing my initial approach.
What, say that, slurred speech and what?
Mush mouth
I heard that.
and slurred speech during my initial approach.
Okay.
And then when my supervisor arrived on scene, we removed them from the vehicle to conduct the SOSTs.
And SFSTs at standard field sobriety tests?
Correct.
Why did you remove them from the vehicle to conduct those tests?
Indications with the slurred speech and mush mouth and the open bottle of Patron.
Indications of what?
Intoxication.
Intoxication with alcohol?
At that time, I wasn't sure what type of intoxication.
Okay. Did the defendant perform standard field sobriety tests?
He did.
Which tests did he perform?
All three, the nystagmus, the walk and turn, and the one-leg stand.
And what were the results of those tests?
They indicated a level of impairment.
On each test?
Yes,
Okay. And so at that point, was the defendant placed under arrest?
he was.
While interacting with the defendant, did you notice anything else that led you to believe that he was under the influence of alcohol?
Yeah, yes, erratic behavior.
What kind of behavior?
Erratic. The like up and down of emotions, which in my experience shows a level of intoxication.
In your experience with intoxicated individuals, can you often detect an odor of alcohol on the person?
Yes,
Did the defendant exhibit this odor of alcohol that you recognized?
a slight.
Slight?
Yes,
Okay. Once the defendant was placed under arrest, was he brought back to the Walton Hills Police Department?
temporarily. I stopped by the police station to grab his paperwork so I could fill out the 2255. He was then transported immediately to Macedonia jail, where we conducted a breath test.
Okay. Was a breath test conducted, or?
We offered, he refused.
Okay. So you don't have any results of a breath test?
It was
for
a,
the defendant?
yes, it was a refusal.
Okay. While at the Macedonia jail, is that where the defendant was booked into jail?
Negative. we strictly do testing there, and then he was booked in at our station.
So you brought him back to Long Hills Police Department?
Correct.
Where he was booked into the jail. When an individual is booked into the jail, are they searched? Is their person searched?
Yes.
Was the defendant's person searched?
Yes.
Was anything located on his person?
Yes, a small baggie of marijuana was located in his jacket pocket.
Okay. And were you present when that baggie was located?
Yes.
In your career as a police officer, are you familiar with marijuana and what it looks like?
Very.
Okay. And so how could you tell that this baggie contained marijuana?
The odor of the green particulates in the sandwich bag.
Where was the baggie found?
In his jacket pocket.
Thank you.
Was that baggie confiscated?
It was, and logged into evidence.
Okay.
When you say jacket, what kind of jacket was he wearing?
I believe some type of leather jacket.
When you say it was a pocket, where was the pocket?
Right pocket. Like,
On the outside or inside?
outside.
So on the right-hand side?
Yeah.
Down by like the hip area, I guess?
Yeah.
Okay.
Was that marijuana ever sent out to a crime lab for testing?
No, it wasn't. We deemed that we weren't going to charge him with conveyance due to it just being marijuana, so we just logged it, confiscated it, and moved on.
Your Honor, may I approach the witness?
Yeah, I'm gonna ask one other question though first. Is there anything else found in the pocket?
No,
Any of the pockets?
just the marijuana.
In all the pockets that you searched?
Yeah.
Good.
Thank you, Your Honor. Officer, I'm handing you what's been marked for identification as State 2. Do you recognize this?
Yep,
What is this?
it's the marijuana that we found.
This is a photograph of the marijuana that you found in the defendant's pocket when he was searched at the jail.
Correct.
Thank you.
I have no further questions, Your Honor.
Cross-examination, Mr. Deeb.
Thank you, Your Honor. Thank you, officer. You said you had a slight odor of alcohol.
Correct.
Coming from around this person, like he was handling alcohol,
Well, speaking to him, so,
speaking to him?
yes.
So in your opinion, it was about his person or was it directly from his mouth?
Well, since I was doing a passenger side approach, I would say about his person.
And there was an open bottle of tequila, or an empty bottle of tequila. Did you dump, is that correct, in the passenger seat?
He was in the passenger seat, correct.
Hey, what did you say, Mr. Deeb?
Wasn't the, I said it was an empty bottle of tequila, and I was gonna get into that. Wasn't the bottle just about empty with some whiskey in it?
Yes.
Okay. So it had some liquid in it, but it was negligible?
I would say that it's a fair assessment.
Okay. So if you looked at that bottle, you pretty much say it was empty?
Yeah.
And it wasn't sealed, like it was brand new, but it was closed, correct?
The cork was in the top, correct.
Okay. Where in the passenger seat was that?
Just like where your butt would sit.
What other items were located in that passenger seat?
No other items.
No other items? Did you check the registration for that vehicle?
Yeah, we run the registration on all vehicles.
So at that time, you were aware that the vehicle was registered to his mother?
Correct.
And he was generally cooperative with you. Didn't give you a hard time during this, other than having to go to the bathroom, correct?
He started off cooperative, and then he increasingly became uncooperative throughout the course of the night.
Wasn't the start of his being uncooperative was because he started to have to go to the restroom, and he was adamant about that, and it took him quite a while to get there?
I would say that's the beginning of it. Yeah.
That's where he started to get upset?
Yes.
But other than that, he wasn't physically aggressive, wasn't pulling away, pushing away, he was just kind of passively not cooperating would be a good statement?
That'd be a fair assessment, passively.
Not wanting to answer questions,
Correct.
you know, just let's get over this kind of thing?
Well, I mean, while he was in my back seat, he tried taking his pants off.
That was when he had to use the restroom?
While we were approaching Macedonia jail.
Well, what?
We were approaching Macedonia Jail.
And when you searched him on the street behind his truck, you didn't find the marijuana at that time?
No, I was strictly looking for weapons for a safety issue.
Okay, so if you patted that down and felt it was soft, you just kind of moved on?
Yeah, I was looking for guns, knives, that type of items.
So you did a second search before he went into the station?
It's a policy when anytime anyone comes into our jail, we'll do a full search.
That's when you found it?
Yeah.
Did he tell you whose piece of clothing that was?
The jacket?
Yes.
The jacket that he was wearing, whose
Yes.
clothing it was? No, we didn't discuss that.
He didn't mention the name of somebody that he had borrowed the jacket from?
No,
You don't recall a conversation like that?
I don't remember that conversation.
Did he deny that the marijuana was his when he found it?
Honestly, I don't remember. We didn't even make it an issue because, one, it's marijuana, and two, we didn't plan on charging him with conveyance with a felony, so we didn't make it too big of a deal.
With you guys, with it being marijuana and being legal now, would he have gotten that back at some point?
No, because technically it is a crime. Conveyance is a crime. Bringing a controlled substance into a secure facility.
But since it was marijuana and you guys got it soon enough, you're like, we're not going to go further with this?
Exactly. We'd have to send it out to a lab and to bring it to court. It's just not worth the effort.
You were pretty sure that it was marijuana?
100%.
Did he acknowledge that it was marijuana?
I don't ever recall questioning him about it because we saw it. We're like, it's marijuana.
Was it pointed out to him? He found it, like we got here?
No, not really. My sergeant got it, passed it to the other sergeant. We just put it to the side.
Where was Darrell when this was happening?
In the room, in the booking room.
Like standing right here, he just took it out of his pocket and handed it over?
No, what had happened was when he comes in, we place him against the wall. He had his jacket on. I took his jacket off, handed it to Sergeant Coath, which is the daytime supervisor. While I was searching Mr. Odom, my sergeant pulled it out of his pocket, handed it to the night shift supervisor, and then we put it to the side while we were booking.
Okay. And that was the end of any discussion of the marijuana as far as this case was concerned?
Yeah.
He did not take any chemical tests, correct?
No breathalyzer. No, he refused the breathalyzer, and we didn't offer a urine.
But with the marijuana being found, as well as an empty bottle being found, you didn't request any other, you didn't go for urine or blood? at that point?
We had enough to charge him with the OVI, with just his failing the SFSTs and the open container.
No further questions, thank you.
Redirect examination.
No redirect, Turner.
All right, sir, thank you very much. You may step down. Does he have some with him? I have the pictures. Statement Cuts, next witness.
Thank you, Your Honor. The state calls Lauren McCarthy.
Good morning. Please raise your right hand. Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Proceed. Ms. Ronick, when you're set.
Thank you, Your Honor. Good morning.
Good morning.
Can you please state your name and spell your last name for the record?
My name is Lauren McCarthy, McCarthy.
Where are you employed?
Lake County Adult Probation.
What's your position with the Lake County Adult Probation Department?
I am the fiscal manager for the office as well as the lab director for the department.
And focusing on the lab director portion, what are your duties as the lab director for the department?
As the lab director, I run screens. I oversee the storage of all of our solutions, the maintenance of our machine, making sure everything is up to date and passing inspection.
Okay. And tell me about the machine that the probation lab has for running screens.
It is called an Indigo Plus analyzer.
What is it?
It is an analyzer for doing urine screens.
Okay. And what does it test for?
It tests for amphetamines, heroin, marijuana, opiates, and cocaine.
And are you, as the lab director, are you in charge of overseeing the maintenance of that machine?
Correct.
Okay. And what does overseeing that maintenance entail?
Every week, whenever we run screens, there's maintenance that gets done on the machine. Like when you start it up and close it down, there's maintenance that's done. And then every year, Thermo Fisher is who manufactures the machine. They come out and they do preventative maintenance on it to make sure it's up to date.
Is there only one machine in the probation lab?
Yes.
So all screens that are run through probation are run on this machine?
Correct.
Did you have to undergo any type of training on the use of the machine?
Yes, Thermo Fisher came out and did training with the lab techs.
And you also completed that training?
Correct, yes.
What did that training entail?
It was a 2-day training just on the policy or the procedures of the machine, how to use the machine.
What is the procedure for the use of the machine?
I don't know where you want me to start.
When a screen, well, okay, so the probation department, the individual officers are the ones who submit urine samples to the lab for screening, correct?
Correct.
Okay, so once you get a urine sample, take us through the procedure of testing that sample.
So whenever we start up the machine in the morning, we have to do a calibration process on it, which is simply the process making sure that the machine is going to provide accurate results. Once the calibrations are done, we do a quality control, run our controls. Those are solutions we put in, making sure that the machine is going to give us an accurate reading. Once those two pass, the calibrations and the controls pass, then we start putting the actual urine samples on the machine.
And the urine samples are run through, and then is a result given to you?
Yes, the machine, we have a qualitative machine, so it's going to tell us if the sample is negative for a drug or positive for a drug.
Okay. And the drugs that the machine tests for, are there cutoff levels for what would indicate a positive or a negative?
There are.
And does each drug have its own cutoff level?
Yes.
Specifically for marijuana, what is the cutoff level there?
50 nanograms per milliliter.
So what does that mean, as that 50 nanograms per milliliter being the cutoff level for marijuana?
Any sample that is 50 or above is going to give a positive result.
Okay, so that's the amount of the substance that is detected in that sample?
Yes.
Okay. Are you familiar with the screen that was run in this case on Daryl Odom that was collected on July 28th of 2025?
I am.
Did you run that drug screen?
I did.
Okay. And what date was that drug screen ran?
I believe it was on July 30th.
Of 2025?
2025, yes.
And did you receive the results of that drug screen?
I did.
Can I approach the witness, Your Honor?
You may.
Okay, Ms. McCarthy, I'm handing you what's been marked as Case Exhibit 3. Do you recognize this?
Yes.
What is that?
These are the final test results for that screen, Daryl Odom's screen that was taken on the 28th and ran on the 30th.
And what are the results of that screen?
It looks like it is positive for cannabinoid and negative for amphetamines, cocaine, heroin, and opiates.
And does it give a level of cannabinoid in the screen?
It does.
And what is that level?
82 nanograms.
Okay, and it gives that level just for purposes of showing that it's over that cutoff of 50 nanograms.
Correct.
Once you receive a positive screen, what do you do?
Any positive screen is,
Thank you. Good.
if a screen is positive, it is rerun on the machine. It will get 2 runs on the machine that day to make sure it's going to confirm positive. So that screen did, and that was the final result of that. And then any sample that's positive, we save and we freeze until the court hearing is finished.
Okay. And when the machine is going through these, you said there's yearly sorry, I don't know the word that I'm looking
The
for.
preventative
Yearly quality
maintenance?
control done by the company?
Correct, there's preventative maintenance done by the manufacturer every year.
Okay, and does that maintenance include testing the accuracy of the machine's ability to test for each of those substances?
Yes, they run our quality controls and our calibrations and controls as well before, when they're done with their maintenance, to make sure everything is running as it should.
Okay, and so that machine, the last time it was tested, passed for, specifically for THC detection?
Correct.
I have no further questions, Your Honor.
Cross-examination.
Thank you, Your Honor. With that positive screen that Mr. Odom had, are you still looking at that?
I don't have it anymore.
I'll just- there were other things that it appeared to have, it said amphetamine, a measurement of 34. Is that from his sample?
Those were all from that sample that day, correct?
And a 96.0 for cocaine? And 28.0 for opiate?
She doesn't have the report in
I
front
don't
you
have
don't
it in front of me, I'm
It's
sorry.
right up here, Mr. D. if you want.
Sorry. There are, looking at the amphetamine, the cocaine, and the opiate, there were trace amounts of that, or small amounts of that in his sample, correct?
Yes, that is what the measurement is, correct.
And those are well under the prescribed limits, correct?
Correct.
How would something like that get into a sample?
I can't speak to that. I can only speak on the results were negative.
Okay, but is it possible that certain things, by the people you hang out with, the locations you have, the things you touch, food you eat or drink, could that have an effect on that?
I can't answer that.
What is the range for cannabinoids? 0 to what?
Our cutoff level is 50 nanograms, so anything above that would be positive.
Okay, what is the highest above that the scale goes?
I don't know that there is a scale, it's just the nanograms, the amount that is in the nanograms that are in there.
Could be up to 10,000?
I don't know the answer to that.
Okay. So we know that the cutoff is 50 nanograms per milliliter.
Correct.
But you don't know, you don't know if it goes to 1,000, 10,000, what the top scale is. You just know this is very close to the low end.
I just know that he tested positive for that on the 28th.
And you only check that one number. Anything higher than that, you disregard it. Anything higher than 50, you just mark as positive and move on.
Yes, our machine will either give us a positive or a negative. So the machine will tell me it's positive or it's negative.
Okay. Some of those other numbers that you took a look at,
Correct.
you wouldn't even take a second look at those because they're under. That be fair?
Because the machine stated they were negative.
At that level, telling us that it's 82, 82 nanograms per milliliter, which over the 50 milliliters, that doesn't tell us when or how he ingested anything, correct?
I can't speak to a level. I can just speak to a positive or a negative.
Okay. And that you can't extrapolate from that result that you see as positive, how that got into the person's system.
I
You would
cannot.
never be able to tell, right?
Correct.
Nothing further, Your Honor.
Redirect examination?
Thank you, Your Honor. Just for clarification purposes, Your Honor,
Yeah, sure.
Mr. D brought up to you that the amphetamine tested at a level of 34, the cocaine tested at a level of 96 nanograms per milliliter, and the opiates tested at a level of 28 nanograms per milliliter. Just for clarification purposes, that means that the sample contained that amount of each of those substances, correct?
That can tell me that he was negative for all the other substances.
Right, but this amount that it lists here under measurement, the machine is measuring that amount of the substance in the sample.
Because I can't speak to the levels, what those numbers mean. I can only speak to a positive or a negative.
Okay, but the machine does spit out measurements. from the
Correct.
sample.
Correct.
And it's getting these measurements from the sample.
From that set, correct.
Re-cross-examination?
Nothing further, Your Honor.
All right, you may step down. Thank you.
Thank
State may call its next witness.
State has no further witnesses at this time, Your Honor, and would rest pending the admissions of State's Exhibit 1, 2, and 3.
Any objection to exhibits 1, 2, or 3?
No, Your Honor.
All right, those will all be admitted. Does the defense intend on presenting any witnesses?
Yes, Your Honor.
Please call your first witness.
We call Cheryl Hammonds, the mother of Darrell Odom.
Hammonds?
I was asking her about the reference, what it was in there. She was saying anything above that, that's all.
Talk to me.
Go ahead. I understand that. We're going over it again. He told you that. We know that. What-
Stop it right there and have you raise your right hand. You swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes. Now you have a seat. It's on wheels, so be careful there.
Okay, thank you.
Mr. D, whenever you're ready.
Sir, what's your relationship to Darrell Odom?
No, why don't you have to state her name here for the record, know that.
Let's state your name and spell your last name for the record.
My name is Cheryl Alicia Hammonds. Last name is spelled Hammons. And my relationship to Darrell is I'm his mom.
Where do you reside?
1899 Roxbury Road, East Cleveland, Ohio, 44112.
Do you maintain a relationship with Darrell?
Yes,
How often do you think you see him?
a couple times a week, every other day. I'm mom whenever he pops up.
When he was having his issues with the Walton Hills Police Department, whose vehicle was he in?
He was in mine.
And did he have permission to use that vehicle?
Yes, he did.
Now, you're aware that there were items in that vehicle that were still yours, correct?
Yes, sir.
One in specific, bottle of tequila.
Yes, Patron.
Whose bottle was that?
That was my bottle.
And when was that bottle placed in that vehicle?
Earlier the week, I had gone out and hanging out with a couple of my friends, and we left an establishment, and I had the bottle. It was empty. I meant to discard it, but, just flipped it over to the side of the passenger side of the vehicle.
Okay.
So it was in the front, sort of front seat.
Did you tell Darrell about that?
No, I didn't tell him. I didn't,
What was your plan for that bottle? You said
to
that-
discard it.
Discard it?
Yes,
How come it didn't get discarded?
just happenstance. Just, my error of not, clearing out the vehicle before I released it to Darrell to drive.
How much tequila was in that bottle when you left it there for the last time that you saw it?
It was empty. So whatever the little cracks or corners, but it wasn't enough to be considered a full drink, but for the most part it was empty.
A few drops would be left in it?
A few drops, yes.
And you were with Darrell when he was taken into custody for his positive marijuana test, were you not?
Yes, it was.
Did you happen to speak with probation?
Yes, I did.
And how did they characterize his positive screen?
Objection.
Sustain. No, overruled. You may answer.
I'm sorry.
You can answer.
You can answer.
When they showed the test, showed me the paperwork, excuse me, the gentleman was like, here's the different levels, and he gave a high and low, and basically said that it was kind of on the low side, but gave me the number of like 80 something versus the 50 something, but he clearly showed me that.
He made you aware of the testing and where it was?
I'm sorry.
He made you aware of the test that they had given to Darrell?
Yes. Yes.
How did this happen? You were there, or you talked to him?
I was there. I came up, cause I bring him, every week. I drive him here, pick him up, so, you know.
Okay,
So when
Also the day
when
that-
they
the day that this
detained, yeah, they
happened.
detained him.
gotcha.
I went upstairs to the probation department and,
I got you.
yeah, tall guy, little short lady, yeah.
The day that he was taken into custody, you were there with him.
Yes,
And Mr. Berry went over those results with you.
yes,
And characterized those results as low.
yes.
Nothing further.
Cross-examination.
Thank you, Your Honor. Good morning, ma'am.
Good morning.
Just very briefly, the day that your son was driving your car.
And I'm sorry, who are you?
Doesn't matter. She's the prosecutor.
Oh, I just didn't know who she was,
Okay.
sir. Yeah.
My name's Sarah Hronik. I represent the state of Ohio. On the day that your son was using your car and got pulled over by the Walton Hills Police Department, that was, are you aware of what time he was pulled over?
It was in, like, early morning, I want to say about maybe 1 or 2 o'clock. It was early morning.
When had you given your son permission to use your car?
I had given him permission to use the car earlier that day.
Okay.
Or
Were you
the day before. And
were you-
go ahead, I'm sorry.
were you present with him when when he was pulled over?
No, it was not.
Had you been present with him within the few hours before he was pulled over?
I would say earlier that evening, yeah. So what you call a few hours?
If he was pulled over at 1 or 2, were you with him after midnight that night?
No, I was not.
So you were not present at the stop. Do you have any knowledge of how he performed on field sobriety testing?
Just based on what he described to me during the field test,
Okay.
you know, after it was over with.
You were not present with him in the hour or so leading up to that traffic stop?
Well, just enough for him to get the keys to the vehicle.
No further questions. Thank you, ma'am.
Redirect examination.
No, Your Honor.
No, you may step down, thank you. You could have a seat back here if you want, or wait in the hall, either one.
Okay.
I'm not sure if you wanted her to remain.
She's welcome to stay. I'm not going to recall her.
Okay.
Patrice Hill would be next.
Stop you right there. If you raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Have a seat. That chair's on wheels, so be careful. Mr. D, whenever you're set.
Thank you, Your Honor. Patrice, will you please state your full name and spell your last name for the court, please?
Patrice Hill, Hill,
And where do you currently reside, Patrice?
Willoughby,
What's your address?
941 Shadow Road, Ave, Willoughby, Ohio.
Who resides at that location?
Myself and my daughter.
And are you familiar with Terrell Odom?
Yes,
Can you see him sitting over there? That's Terrell.
yes,
And you have a jail uniform.
yes,
Maintained a personal relationship with him.
yes,
This past summer, were you guys still interacting on a regular basis?
yes.
How would you characterize your relationship at this point?
I mean, it's on good terms. It's a decent relationship. It's a good friend of mine.
How often does he come to your house?
Not that often anymore. Maybe like once a month, once every other. Inconsistently. We speak more on the phone than actually him coming over my house.
What are the types of things he does when he comes to your house?
Usually just hang out, listen to some music. Sometimes I might fix him a meal. Nothing too major.
Did there come a time in July that he would have come over to your house and hung out with you?
Yes.
Now, do you recall what day it was in July that you were together?
It was the end of July. I want to say it was the end of the July. It was on, I don't remember the exact date, but I know it was on a Thursday at the end of July.
Okay. What makes makes you think it was a Thursday? What makes you recall it was a Thursday? Was anything special going on?
I didn't have my daughter, and it's the day that my daughter was gone that he was over.
Okay. So, do you yourself use marijuana?
I do.
I don't know, what sort of schedule or what is your use level? Daily?
Daily.
Multiple times a day?
Daily. It depends on my work schedule, on how often I use it, but it's daily. If I work, I typically work from 7:30 in the morning till about 5 or 6 in the evening. Once I get my daughter down, I usually have something once she's down for the night. If it's a weekend, my daughter goes with her father on the weekends. If I'm off of work, it's a little more over the weekends, but it is consistent and it is daily.
And how do you ingest THC or marijuana?
Two different ways. I smoke it, like flower, THC, and then I also have like a THC infused honey that I use in my tea.
What should I mark as a defense exhibit? I didn't have a sticker. I thought I had.
Mayor, you have any stickers there or not?
A?
Wait a second, Tim. I mean, you can mark that A, but Mary will give you a sticker. Excuse me. You may.
Take a look at this, if we mark it as defense exhibit A, just take a look at that for a second, and ask you some questions.
Okay,
Tell me when you're ready.
I'm ready.
Who took that picture?
I did.
And what is in that picture?
It's my pitcher I used to make the tea. It is the glass, one of the glasses I had poured one day, and it is my THC infused honey.
Where is the THC infused honey? In this picture, where is the THC infused
The
honey?
smaller bottle with the dropper.
Okay, just in front of the largest bottle?
Correct.
And where do you store that, those containers?
The pitcher with the tea, it's stored in the refrigerator. The dropper, it's stored in my bedroom in one of my top drawers.
Why do you store things like that?
So it's out of reach for my daughter.
Now, the bottle that would be in the fridge, does that have THC in it?
I'm sorry?
The bottle that would remain in the fridge, would that have THC in it?
Yes, it would.
And what flavor is that?
It's just regular, like lemon chamomile tea, like sweet tea.
Is it sweet tea? What steps do you make sure that your daughter doesn't have access to it?
She knows what's mine and what she's not supposed to touch, and she's a very well-behaved little girl. So she knows what juices and drinks are for her, and she knows which ones are for me.
You made it clear that that's
It's
mom's
very,
drink and
very
she
clear.
stays away from it?
She does.
What about any other people that are at your house? Do you tell them?
I don't entertain often at my house.
Speaking directly to Darrell, have you and Darrell spoken about your honey tea concoction?
We had not.
You had not?
We had not.
Okay. When he was over at your house, do you believe that he used your honey tea concoction?
I do.
What makes you say that?
So when he was over my house, I had went to take a shower, and he asked me if he had yelled out, "Patty, do you have anything to drink?" So of course I yelled back, "Yep, something, and there's plenty of stuff in the refrigerator." I didn't specify, I just told him drinks are in the fridge.
Okay, and this was one of the drinks in the fridge?
That was one of the drinks in the fridge.
Were there other drinks in the fridge?
There were, but not a lot. So there was like one of those gallons of like Dairyman juice my daughter would drink on. Yeah. And there were some bottles of water. He does not typically drink water ever. And I think I had like a few like squirt, like cans of squirt in there at the time.
So how do you know that he drank from this bottle instead of any of those other drinks?
Because he typically doesn't drink water, so I know he didn't touch that. He's been over and we've lived together before. He knows which drinks are for my daughter, so he wouldn't have touched her jug of juice. And the soda seemed to be the same amount of soda that was in there before he had came over. So.
Did you see him drinking anything?
I did not see him drinking anything. I did not see any empty cans when I had came out of the shower. But there were dishes in the sink, so he could have drank a glass of the tea and put the glass back in the sink with the rest of the dishes.
Did you and he have any conversation about that at that time?
No,
Did he mention anything to you about it?
no.
You said there were dishes in the sink. What were those dishes?
Couple of plates. I had made something to eat. A couple forks. Few cups, like a coffee cup. Probably a couple glasses. It was a few random dishes in the sink.
Were any of those dishes that he was using?
No, because I had cleared his plate, so he was done eating before I went to take my shower. So no other dishes had he been using prior to me going into the shower.
You didn't see a new empty cup on the counter or anything?
Not on the counter, but like I said, it could have been in the sink with the other dishes that were in there.
Thank you, Patrice. Nothing further.
Cross-examination.
Thank you, Your Honor. Good morning.
Good morning.
How often do you drink this THC-infused tea that you make?
Typically every evening.
Every evening? What is the effect on you that it has, if any?
It helps me to go to sleep. It helps
Okay.
me to get a little
So
rest at night.
Would you say, how long have you been using this THC-infused honey?
Roughly about within the last year, so 6 months to a year.
Okay. So you're familiar with the effects of it on
Yes.
you? Okay. And you drink it at night to help you go to sleep, you said?
Correct.
So you do feel the effects of the THC when you drink it?
Yeah.
And then Mr. Deep was asking you about the day that Mr. Odom was at your home. You were in the shower, so you did not witness him drink anything, correct?
Correct.
So you're just guessing about potentially him ingesting the tea, is that correct?
Correct.
I have nothing further, Your Honor. Thank you.
Redirect examination.
Nothing further.
Now you may sit down, thank you. Vince may call its next witness.
May I have a moment? Testify. He can ask you. The prosecutor can ask you a lot of questions. Okay? He's just going to try and make you look good. Well, they're going to ask you the questions. The alcohol, the marijuana, everything. Do you feel comfortable answering those questions?
Yeah.
It's your choice. I can't make you do it.
Yeah.
Your Honor, Terrell Odom would like to take the stand, Your Honor.
Okay. Can you uncuff him, please?
Sir.
Hang on, we're going to... Thank you. Please raise your right hand. Do you swear affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Careful with the wheels on there. You comfortable?
All right.
Mr. Deeb?
Terrell, you are the defendant in this case, correct?
Yes, sir.
Okay. And you are the Terrell Odom that was on probation in 23 CR 891 to Kelly Warren?
Yes.
And you recall when the Walton Hills Police Department interacted with you, correct?
Yes.
Was that back in May of this year?
Yes.
Did you communicate with myself when that happened?
Yes, I did.
And what was one of the first things that we wanted to make sure we did?
Alerted probation and turned myself in.
Okay. And since I called you later in the day, weren't you concerned about calling probation after hours?
Yes.
Okay. And I instructed you to just call and make sure you let them a message immediately.
Immediately.
So you followed through with that?
Yes, I did.
And then subsequent to that, you went and had a meeting with them?
Yes.
And at that meeting, you were arrested?
Yes.
Now, the judge gave you a bond at that initial probation violation. Okay. Do you recall?
Yes, gratefully.
It took a couple of days, but you got out.
Yes.
So we could work with the prosecutor's office to resolve Walton Hills, right?
Correct.
Now, in Walton Hills, they found items in your pocket, or an item in your pocket. Was that marijuana?
I wasn't aware of it when I actually found out about it. Ms. Warren was the one that informed me that they had found weed on me.
So you heard the officer's testimony just a little bit ago that the jacket was not on your person when they found it, correct?
Yes, they had took all of my clothes.
Okay. Did you see when they pulled it out of your coat? And
No, I didn't. When I talked to her, I informed her the charges. She then told me that I also had marijuana on me. I told her no, I didn't have marijuana on me.
okay, whose jacket was that?
It was a friend of mine who had passed.
Passed away?
Yes.
When did you receive that jacket?
We actually bagged his clothes and stuff up, so his clothes have been there for maybe 3 months, 4 months.
When did you get that jacket?
It was at my house, but I hadn't wore it for months. So I had the jacket months prior, but I never wore it.
So on this occasion you were wearing it?
So on this specific day, yeah, I decided to put the jacket on.
As a leather coat?
Yes.
You didn't check the pockets?
I didn't check the pockets.
Now, on that date, you were driving your mother's vehicle, right?
Yes, sir.
Why?
I was going to pick up my aunt from the casino. Her car had broke down.
So where were you? You going to the casino, or were you
I was headed towards the casino parking lot. She was stranded in the parking lot. Her
What
car wouldn't
casino?
start. She needed to jump.
What casino?
The MGM.
And how many items did you have in your mother's vehicle at that time?
No items. I didn't have anything. Maybe a hat that I had on my person.
Did you see that there was a bottle next to you in the passenger compartment?
I absolutely did not pay attention to it. I got in the car and I took off to go give her a jump. It was late at night. I had just woke up. I paid it no attention. If I would have seen a liquor bottle on the passenger seat, I would have moved it when I seen the sirens. I wouldn't have left it there on the passenger seat for a cop to see.
Do you know where the officers would have found it?
No. Once I got out the car, they never let me back in.
And during the time you drove that car, did you see that bottle?
I didn't see it. I never seen it.
Now, with the positive drug screen that you had this past July, did you take a drug screen the week of July 21st during your visit?
Yes, I've taken the drug screen every month, 2-3 times a month since I've been on probation, which is 20 months.
So this past July, did you take a drug test every time you saw probation?
Every single time I go to probation, maybe once or twice, I haven't took one, but the majority of the time I take a test for the last 20 months.
Okay, I'm just talking about the last 3 months.
Yes, since I've been with Miss Callie Warren, I've been taking the drug test every week, maybe except for one time.
So you came back on, when you came out on the 28th, you gave them a drug screen. You got the sample, correct?
Right.
All right. And then you were allowed to leave probation.
Right.
What happened the next time you came back?
I showed up, regular procedure, put my phone down, went through the scanner, gave a urine sample, signed my initials, and was headed back to Mrs. Warren. Went to wash my hand, was headed back to Miss Warren's office when Mr. Berry approached me and asked me how my day was going. And I told him that it was slow, that it's been a slow week. He said it's going to get real slow for you. I have a warrant. You tested positive for marijuana. I explained it.
Did you discuss that with him?
I explained to him that couldn't be possible, that test me right now, that I know I don't smoke weed, I don't come in contact with it. Ever since you revoked my bond for not going to the dispensary, I have not touched marijuana. So I told him that can't be possible. He said that it was and cuffed me to the chair.
Had you smoked marijuana at any point?
Never.
Did you take any edibles that you know
I
of?
didn't take any edibles at all.
Now, you heard Ms. Hill testify. Were you at her residence?
Yes, I was.
Towards the end of July?
Yes, I was.
Did you drink anything from her fridge?
That pitcher of tea.
Did you have any idea of what was contained in that tea?
No, I didn't. We had just got done eating pork chops and, you know, having a nice night with each other. And she was in the shower. I was about to leave, and I was thirsty. I just went in there and drank the tea.
Why'd you pick the tea?
I mean, I like iced tea. It was the better choice out of the things she had.
How much tea do you think you drank?
A whole full cup.
And do you know what day of the week that was?
I wasn't sure, but I'm pretty sure she was accurate if she said her, because her daughter wasn't there.
And the time that you were at her house where you had ingested that drink, when was your next probation visit?
That Monday.
And you did give them a screen that Monday?
Yes.
And you know that screen was over the cutoff of 50 nanograms per milliliter?
When I discussed it with Mr. Berry, he explained to me that, because I told him maybe, you know, I was just at a party, it was a lot of smoke in the air, so maybe somebody secondhand. He said no, that the levels were cut off at 50, which means that it was dirty, that 80 is low, but it's still considered dirty.
Could you explain to him how that test became positive, or how you would have given a positive screen?
No, I couldn't.
Nothing further. Thank you very much.
Cross-examination.
Thank you, Your Honor. Morning, Ms. Rodham.
Good morning.
Referencing the leather jacket that you were wearing when you were pulled over by the Walton Hills Police Department, at what point of the day or night did you put that jacket on?
It was probably towards the evening. It was like, actually, maybe like 11-ish.
Okay, so at the time that you were pulled over, were you wearing the jacket?
Yes, the cop had actually searched me right there on the scene, and he didn't feel it either.
Okay, but you were wearing the jacket when you got pulled over?
I was wearing the jacket.
Okay, and you heard the officer testify that this happened at about 2:30 a.m.?
Uh-huh.
So you'd been wearing the jacket for a few hours at that point?
Yes.
Okay.
No, I had taken the jacket off and put it back on.
Okay.
I wore it outside. Once I got inside to the area I was at, I took the jacket off.
Were you with anyone else at the time that you were pulled over?
No, I wasn't.
Okay. And you were wearing the jacket when you were pulled over?
Yes, ma'am.
Okay, so the jacket at that point was under your control?
Yes, ma'am.
And what was in the pockets was under your control?
Yes, ma'am.
And the vehicle that you were driving, that was your mom's vehicle?
Yes.
Okay. And you did not see the singular bottle of Patron sitting on the passenger seat next to you?
No, I didn't.
Okay. But the vehicle was solely under your control at the time you were pulled over?
Yes, ma'am.
Okay. And so that alcohol bottle was solely under your control at the time that you were pulled over?
No, ma'am. It wasn't. I didn't see the bottle. How would it be under my control?
Was anyone else in the car with you?
No, it wasn't.
No one else was in the car with you?
At all.
Okay. What had you been drinking that night?
I haven't been drinking at all.
Are you aware that you failed 3 standard field sobriety tests that night?
That's what he said, yes.
Okay. So are you aware that that means that you exhibited horizontal gaze and nystagmus in your eyes when you were tested?
Yes, ma'am.
And you're aware that that means that you failed the walk and turn test?
Yes, ma'am.
And you're aware that that means that you failed the one leg stand test?
Yes, ma'am.
Okay. How can you explain your slurred speech and the odor of alcohol on you if you had not been drinking that night?
Maybe he smelled the alcohol because it was a container on the passenger seat. He said he came to the passenger side of the car.
Okay.
So maybe he smelled the bottle there.
The corked bottle of Patron that was almost completely empty?
That was completely empty.
Okay. Why did you refuse to submit a breath test when you were asked to submit one if you hadn't been drinking?
Because at the time I had been begging him for maybe close to 45 minutes to an hour to use the bathroom. He stopped at one police station and refused to let me out. He said he went in and remember he said he pulled to grab the paperwork, correct? When he said he stopped the first time at Garfield to grab the paperwork. He sat me in the car for maybe 15, 20 minutes. I asked him could I go in with him then to use the bathroom. He just ignored me and went in. When he came out, I asked him again, could he take me in there to use the bathroom? He ignored me and drove off. We went from Garfield to Macedonia, which is like a 20, 25-minute drive on the freeway. The whole time I'm telling him that I'm about to urinate on myself. That's when he's saying I'm displaying that I was trying to pull my pants down in the back seat. I was telling him that I didn't want to urinate on myself. We then got to the station. They're asking me questions. I was agreeing initially to take the breathalyzer. That's why we went. But once I urinated on myself and they degraded me, I told them that I had nothing further to say.
Once you urinated on yourself, what?
I told them that I had nothing further to say, that I wasn't talking anymore. I started crying and asked them to take me to a cell.
Okay, but you said once you urinated on yourself and then you said something else, then you decided.
Yeah, once I was answering all their questions, I was filling out the paperwork, and I asked them, can I please use the bathroom? I'm jumping up and down in the station, asked them could they uncuff me, could I use the bathroom? Once they made me urinate on myself, I sat down and I said I don't have anything else to say.
Okay, so then at that point when they asked you to do the breath test, then you said no.
I didn't say I refused to talk from that point.
Okay, but you did not take the breath test after you urinated on yourself.
And that's when he took my coat.
Okay.
He sat up here and just said that he took my coat. I just handed it to him. No, they took my coat once. They gave me jail wear to put on because I soiled my clothes, and I asked them was they gonna make me sit overnight in soiled clothes. That's when he gave me prison stripe pants and a shirt. So that's when I gave him my jacket and the rest of my clothes. And when they got that, that's when they found.
Well, that was back at the Walton Hills jail, though, right?
No, that was there.
Okay, so you were searched and booked at the Macedonia jail, but you weren't kept at the Macedonia jail.
That's where they took my clothes at. He explained it, the incident totally wrong.
Okay. And you stated that since you got violated for not using a dispenser, you have not touched marijuana?
I have not touched it.
How long ago was that?
That was August 23.
A couple years?
Yes, August 23. I have a record where I've been taking urine tests 2-3 times for over 20 months.
Okay.
I have never failed it for alcohol, for weed, for anything.
So you would have no tolerance built up to marijuana, is that correct?
Excuse me?
You would have no tolerance built up from continuous use, right? Because you haven't used in a couple years?
No, I don't, I guess not. I don't know what a tolerance level, how you would gauge a tolerance level.
When you drank the iced tea, did you feel the effects of the THC in the iced tea?
No, I didn't.
I have nothing further, Your Honor.
Redirect examination.
Nothing further, Your Honor.
All right, so you may return to your seat.
We'd ask for the admittance of Defense Exhibit A, and we would rest.
Any objection to Exhibit A?
No, Your Honor.
That'll be admitted. Any rebuttal testimony?
No, Your Honor.
Right out here. Well, Mr. Odom, wait till he sits down. We're going to hear from the state.
I'm sorry?
Any closing comments you care to make?
Your Honor, just that the defendant was pulled over by the Walton Hills Police Department. He failed his field sobriety test. The officer testified that he was exhibiting signs of intoxication, slurred speech, and there was an odor of alcohol coming from him. The state does not believe that this empty bottle of Patron, corked and sealed, or corked, would have caused that odor of alcohol. The defendant also was giving the officer some trouble that evening, did urinate on himself that evening. But the most significantly, the state finds that the failure of the 3 field sobriety tests and the odor of alcohol indicate that he had used alcohol that evening. He was in possession and control of the marijuana that was confiscated from his jacket, or his deceased friend's jacket that he had been wearing that evening. And the defendant states that he did ingest the tea that contained the THC in it causing him to use that THC. So the state is asking the court find that he did violate his probation. Thank you.
Thank you. Mr. Deeb?
That's right. I believe that they fall short of their burden to show that he's violated his probation. On that date, the officer testified that he had the odor about him, directly from his mouth or anything else. He said he approached from the passenger side and he could smell just about the area, not specifically from my client's mouth or anything. It was after 2 in the morning. He says he failed those field sobriety tests. But my client was taken around for over 45 to 55 minutes trying to use the restroom, and they just left him sit in a vehicle, and he was distraught by that. So the treatment that he received was concerning to him, and he chose not to give a breath sample, which we really wish he would have, because the way they treated him, he didn't want to cooperate with them any longer, since all he wanted to do was use the restroom. They never requested any other blood or urine tests, just the breath test. Otherwise, he was passively going along with their booking. The alcohol that was in the car, an empty bottle that would have been sitting there. There's no evidence that it was, when it contained alcohol, how much it contained, whether he used it, how long it had been sitting there in his mother's car. Even if he would have known it was there, which he testifies he didn't, it was an empty bottle. Basically, that would say that we can't even take any empty bottles of alcohol to the garbage.
Empty. I mean, you can see it. You can see the bottle.
And the jacket that he had put on that he received from his friend, he hadn't checked. The officer did search him, didn't find the marijuana at that time. Yes, he was searching for weapons. He was surprised to find that out from probation, because when they did find it, as the officer testified, another officer found it, showed it to the officer that testified, and then they moved it to a different area. Didn't give it to Mr. Odom. And unfortunately, moving to July, being at his friend Patty's house, he has no reason to distrust her, goes into her fridge to grab a drink. She's not worried about an adult, not even thinking about it, because in her world that's normal. He takes a drink and everything's fine. And unfortunately, here's where we're at. The screens have been clean. That is a very low reading on that scale, 82 above a 50 nanograms, which makes that seem very plausible that it was either a minor ingestion, a minor inhale from something, but not that he was regularly using to get high, because that number would have been higher. Thank you, Your Honor.
Mr. Ronick, any response?
No, Your Honor.
We're going to take a 5-minute break, and then we're going to be right back on.
All rise.
All right, the court has taken the opportunity to consider the evidence, review the exhibits. And considering all the foregoing, we're going forward on 3 Rule 8 violations. The court finds the state met its burden in establishing that the defendant violated each of those Rule 8 violations. On the night of the incident, initial incident, the defendant was stopped. He was found to have slurred speech, failed each of the 3 field sobriety tests. There was a slight odor of alcohol coming. If it was under his version, it was a closed bottle that had been closed for a long time. It wouldn't make any sense. Exhibited erratic behavior, refused to take a test. It's all evidence of impairment. Brought to the police station, there's a bag of marijuana found in a jacket pocket. He has explanations for everything that happened, and it's not credible. On the night of then in the July incident, he tested positive for marijuana. Again, comes up with explanations for everything. But he's in violation. The court finds the state did meet its burden in establishing that each of these 3 Rule 8 violations. Mr. Deeb, is there any reason not to go forward with sentencing at this time?
No, Your Honor.
Anything you want to say on behalf of your client?
I believe that Darrell has been doing, taking major strides this year. I know that he's been found guilty of his probation violations, but he's worked hard to get his license. He did clear that up, so that was a milestone that he was very happy to get back on his feet. He has got his company. He picked up a few more contracts. He was able to support himself. He is making better choices with family and friends that he's hanging out with. His only issues since he's been on probation have been with driving.
What?
And with marijuana. Driving and with marijuana, or the alcohol in this instance. But he has not gone back to any of his old ways that his criminal history would show you that he's been doing. But he's been there for his mom, he's been there for his kid, and he's been making better choices and trying to get his career off the ground. Your Honor, he does not want to go to prison. He does not think that's going to be helpful or a place where he can grow. But I understand that there's a punitive element that the court is going to impose. But what he would ask is for the court to take leniency and give him possibly a little more jail time and allow him to get back to the positive things that he's been doing. If the court wanted a scram bracelet or something, he would be more than accommodating, do something along those lines, or GPS. And he really has been focused on not using marijuana. He was genuinely surprised by why that test would have been even just over the minor, or the base limit. Thank you, Your Honor.
Mr. Odom, you have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say at this time?
Yes, sir. Since I've been on probation with you, I have really turned my life around, and with the help with Lake County probation, it's forced me to do the right thing. I actually had my level dropped from high security to low security. Is how I even got on Ms. Colley's caseload. And like he said, I've been complying. I go 2 meetings every week. I do my everything that you have set forth for me to do. I've met all those criteria up until the point where I called the OVI. I've changed for the better, and I give that thanks to Lake County Probation, because they forced me, without a shadow of a doubt, to do the right thing. I know that I'm before you again saying the same thing that I said before, asking for your leniency, for your another chance, because I actually have, within this 20 months, I have 4 months left on probation. I would have been done. Within this 20 months, I have grown tremendously as a person, not just as a citizen, as a father, as a son, as a everything. I've done everything that I can do to please this court and to please Lake County Probation. I know it sounds like I have an excuse for everything, and just to be honest, it's just a horrible strand of bad luck at the end of a milestone that I was almost done with. Like, I've done everything you asked me to do, down to a T, to the meetings, to the dentist. I don't even go to, I have one doctor. Everything you put on that paper, every checklist for 20 months. I have done it. Towards the end, this is a major F up. But for 20 months, I have done everything. I live my life based on your rules for the last 20 months. And I just asked you for a chance to complete my probation and to get off in January 5th and move on with my life. I'm already doing better. My company's all right. I'm legit now. I don't do drugs. I don't participate with drugs. I don't even run with the same crowd no more. Like, I've changed my whole lifestyle up because of Lake County probation and because of you. And I just want a chance to, I don't want to go to prison. I'm asking you, please don't send me to prison.
Thank you. Mr. Deeb, anything else?
Nothing further, Your Honor.
Sarah for the state.
Thank you, Your Honor. The defendant, based on the original charges of this case, the tampering with evidence, felony with the third degree, and the defendant's pretty extensive criminal history of serious crimes, the state also is looking at the defendant's long history of when he has been put on probation for those serious crimes, violating oftentimes more than once. He has a long history of probation violations dating back to his 2000. Well, he had the 2000 case for the attempted kidnapping, several probation violations after he went to prison in that case, the 2005 case of attempted trafficking, several probation violations in that case, 2006 case, aggravated burglary with the gun specification, went to prison again in that case, 2007 case for aggravated robbery with gun specifications and weapons under disability, went to prison and violated parole on that case. Then in the 2017 involuntary manslaughter case, several probation violations. I mean, at 2021, having weapons under disability, probation violations. It appears that the defendant is not amenable to community control. This is not the first time he's violated in this case. He had a prior violation in this case, and now these 3 violations here today. So the state is going to ask that the court adopt probation's recommendation for prison. Thank you.
This court reviewed the original pre-sentence report and investigation. I've considered the facts of the original offense involved and nature of that. I've considered what's been said here in court by the defendant, his lawyer, the prosecutor. I've considered the defendant's performance on probation. All this was considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, I will incorporate all the findings I've made at the time of the original sentencing hearing regarding the seriousness factors and the recidivism factors, with the additional finding that the defendant has again failed to comply with the previously imposed sanctions ordered by this court. You know, when I first got a big break in getting community control sanctions, with the history that he had, and we heard just some of it now, prison certainly would have been the probably the right sentence at that time, but I gave him a break. And at that original sentencing, you said, quote, "I will not violate probation, not one rule if given the chance. If you see me again, you can dog me." And I saw you again. Sure. And then you violated, and I didn't do that. I still gave you another chance. And now we're back again with multiple violations here. You've gotten a leniency from this court. At this point, prison is consistent with the purposes and principles of the sentencing. The defendant's not amenable to community control sanctions. Therefore, it will be the sentence of this court. And on count 4, tampering with evidence, defendant served a term in prison of 18 months. He has credit for 223 days he's already served. I need to advise you upon your release, you may be placed on post-release control for up to 2 years. If you violate any of those conditions, the parole authority can return you to prison as punishment for violating the rules for another 9 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Defense order the penal cost. The court disapproves the defense placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Is there anything else for the record at this time, Ms. Hronik?
No, Your Honor. Thank you.
Mr. Deeb?
No, Your Honor.
All rise.
Thank you, Your Honor. We're present in the matter of State of Ohio versus Michael Polinsky, case number 25 CR 472. The defendant is present in court with defense counsel Rush O'Connor. We were previously in court on July 31st, 2025, where the defendant pled guilty to count 1 of an indictment, trafficking in fentanyl-related compound, a felony of the 5th degree, count 2, aggravated trafficking in drugs, a felony of the 3rd degree, count 3, trafficking in a fentanyl-related compound, a felony of the 5th degree, and a lesser included offense of count 4, possession of a fentanyl-related compound, a felony of the 5th degree. The defendant was found guilty at that time. The court ordered a pre-sentence investigation and report. The state has had and a drug and alcohol evaluation. The state has had the opportunity to review those reports and is prepared to proceed with sentencing. Thank you.
Thank you. Mr. O'Connor, any reason not to go forward with sentencing?
Your Honor, we're prepared to go forward today.
Anything you'd like to say on behalf of your client?
Thank you, Your Honor. Your Honor, Mr. Polinsky, I have gotten to know each other quite well during this stretch of time. Mr. Polinsky has been in jail for the past 165 days on this matter. So just to start off, I would ask that he be given credit for that time. He has not bonded out at any point in this matter. But Mr. Polinsky, and he'll be able to address a lot of this in his own words, but recognizes that as far as his record goes, that he's had long issues with probation. However, I think this time over these past 165 days has given Mr. Polinsky a lot of time to think things over, to realize that he's heading in a dangerous route if he continues this path. Whether a continued cycle in the criminal justice system or potentially risking a potential overdose, as luckily he survived a previous overdose. But Mr. Polinsky recognizes he needs to get sober. He wants to be able to get sober. His mom, who's here in the courtroom today, very much wants to support this goal. And so Mr. Polinsky, I think what he recognizes his biggest mistakes in his past attempts for treatment is that he felt like he needed to be in programs that were longer than the programs he necessarily did. Yes, he has done NeoCap back in, I believe, 2015. However, I think he was shortly afterwards just dealing with outpatient and aftercare at that time. Mr. Polinsky recognizes at this point that he needs, one, plenty of time to stay sober, but also believes that NeoCap, which my understanding would take he believes that NeoCap would be the best program for him right now due to the length, the fact that he would be in a lockdown facility, and be able to truly commit to the treatment. Followed by that, he would ask that instead of being released, that he be, at that point, referred to an inpatient residential program so that he can work further with their treatment program to continue his treatment while being in an environment where he knows there will be no drugs around. From there, he would seek to be living in sober living so that he's able to continue to create a support network away from his old friend network that ultimately would only encourage him to get back into his old habits. Mr. Polinsky wants to be able to address his drug concerns and wants to be able to live a long life, and he recognizes that the two are incompatible. But he's reached a point, I truly believe, that he's sick and tired of being sick and tired and wants to be able to address all of this. He recognizes his record previously on probation has shown an unsuccessful path, but he recognizes the only thing he can do is show it through action. And so he recognizes he would be on a very tight leash on this matter due to his past record, but we would be asking consideration that he be able to be placed on community control on these matters, that he be placed in NeoCap. He's also willing to serve any additional time prior to NeoCap just to show that he truly is committed to the focus on being in a sober environment and getting clean. But because of that, we would ask consideration that he be given the opportunity for community control, and he's willing to jump through whatever hoops the court deems appropriate. Thank you.
Thank you. Mr. Polinsky, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
Yes, Your Honor. Should I stand or?
Whatever you're comfortable doing.
Your Honor, everything my lawyer said is true. I have prior numbers for drug possessions. When I was 17 years old, I got ran over by a car and have had dealing with chronic pain since. I had metal rods all on my right side of my body. I have erectile dysfunction because of it, and these were all issues I was dealing with at a young age, at 17. shortly after I was healed and back by 18, I caught my first case. I've been dealing in and out of the court system for the past 10 years. I have been through the ringer. I started off just using heroin and went to jail, started using crack, went to prison, started using meth, got out, tried to use a combination of different drugs, and never got the same results. They say, definition of insanity is doing the same thing but expecting different results. I've done it and tried it all with different substances. And here I am again. I just got released from prison in September of last year. 2 days ago would have been a year that I had been out from the halfway house. The only reason I left the halfway house is because my mom wanted me to come home. I felt like I should have stayed in there to get myself together. Just coming back, staying at my mom's house, that's not what's helped me in the past. I've shortly after always gone out and used again. So I came home from the halfway house, and while I was in prison, I got on the MAT program, I was on methadone, which is basically medically prescribed heroin. And I was on a low dose, and it was causing me to nod out and be out of it all day long. I wanted to get off of it because I didn't like the halfway house. Probably peed me 100 times because they thought I was on other drugs but I was just on my medication that's supposed to help me. I was trying to get off of it. So I get released from the halfway house in September. I'm home, back at my mom's house, still continuing taking the MAT program, methadone. I missed a dose one day, and like I said, it's like hospital grade heroin. When you miss, you're going to be sick, and I didn't want to be sick and uncomfortable. So what I did was I went to get something to make me feel better because I didn't want to be crawling out of my skin feeling like I was going to die. I used fentanyl or heroin or whatever it was. I felt healthier doing that because it gave me energy compared to being all knotted out and drowsy all day. So within a month and a half of being released, here I am using again on a daily basis, trying not to be sick. That went on, and then that leads me into my case. I'm not going to say what I did. I'm not going to lie and say I didn't do it, not whatever. I was using and selling drugs to support my habit. And it got out of control and started spiraling out of control very fast. When my use increased, my tolerance increased, I'm using different substances. I wake up in the morning and it would take me 4 hours to even be functional ready because I would try to be, I'm an IV user, so I've collapsed all my veins don't work anymore. I'd be sitting there trying to shoot up for an hour, dehydrated, because I didn't drink water, and it's just a vicious drug-induced cycle. And after 4 or 5 hours, I'd finally be capable to move around after I've done heroin, meth, cocaine, downers, uppers, whatever, to be feeling like I'm functional. And then I'd start my day, and my day would consist of just being high, nodded out, and doing whatever. So that went on for a couple months, which leads me, I've overdosed twice this year from Trank, which is the new drug that they're putting in fentanyl, which is a horse tranquilizer that eats away at your skin and basically tranquilizes you and puts you out to where you're unresponsive, and Narcan has no effect. And I'm doing this on the regular now. And I know it's wrong. I'm hating myself and hating my life while I'm doing all this, but my addiction is so strong that I couldn't bring myself to go to get help, even though that's what I truly wanted. And then I caught my case during this time. I gave somebody drugs, sold somebody drugs, and they wore a wire on me. I hold no resentment against that person because I understand it. They got in trouble. They wanted to get out of trouble. It's unfortunate it was me, but at the same time, I'm blessed and grateful that it happened because where I was headed, if I wouldn't have came to jail, I would have died. Had it been an overdose, me getting robbed, or just my body shutting down. I was 120 pounds when I came into jail. They took me to the hospital twice because they didn't know if I was going to die from my withdrawals. I'm 170 pounds now, so I've gained 50 pounds. I've been working out every day. I do almost 1,000 push-ups at a time. When I went to do a push-up when I first started, I did 4 and hit the floor. I was dope sick for 35 days. I didn't sleep for the first 25 days. It was miserable, horrible, but it's what I needed because jail was the only thing that was going to get me to stop. As my lawyer said, yeah, I've been on probation. I've been through this court in the past. You actually sentenced me to prison on my previous number, and I had asked to go to prison. I didn't even ask for community control because, truthfully, back then I didn't want to stop. I still had resentments. I still had, I still wanted to live. I enjoyed living that lifestyle. I didn't see a problem with it. I embraced being a drug addict. I'm not gonna. That's where it was. I was young, dumb, and now I'm almost 30 years old and facing a lot of time. And it's like, as my lawyer said, I'm sick and tired of being sick and tired. I've been through the ringer. I've overdosed over 20 times. I was telling somebody in my pod the other day about, how my mom's still there and supports me. My mom's an amazing person. She's here today in court for me. She's been here and you know what? I excuse my language, but I keep shitting on her. But it's not me as a person. I love my mom to death. I'd do anything for that woman. It's this addiction. It's the greatest thing and the worst thing in the world. Once you inject heroin, it's horrible. I wouldn't wish it upon my worst enemy. And then the addiction that comes with the other substances and stuff too. It's not me. As a kid, I didn't say, I want to be a drug addict. I didn't expect to go to prison multiple times, but it is what's happened. But I want something better for myself. When I first came into jail, first thing in my head, I wanted to get out and still get high and use, whatever, because I was still in that mindset. And as I've been in there throughout the couple months, my thoughts, my whole actions, the people I talk to, what I talk about, everything has changed. I've been reading the Purpose-Driven Life. I've been reading the AA and NA books and actually trying to take it seriously because nothing else has helped me except for the couple times I did have brief stints of sobriety, working the program, doing that, but I didn't take it seriously because I didn't want to stop back then. When I was 18 or 19 and first got sentenced to NeoCap, I had no desire to quit. I just did it to appease the court. Within a month, I violated probation, smoking crack and getting high. Came back, went to prison, got out, met a bunch of drug dealers, and now I got my. Before then, I had to go through other people that used to get drugs. Now, when I went to prison the first time, now I could get drugs on my own. I had no desire to stop. I was back in jail within 55 days of my first release from prison. Sat in jail, went and did 2 more years. Got out, had a good stint from 2017 till 2020 COVID. COVID took me back out. I was using again, different substances, trying to switch it up, went back. Then prior to this, I had this ongoing case. I was on misdemeanor probation. I relapsed, and I just asked to go to prison. I asked you to send me to prison because I didn't want the misdemeanor time that I was about to get sentenced to count for nothing if I was about to have time in this court. So that's why I asked to go to prison. And while I was in prison, I had a breakup with a girlfriend. I was depressed. When I got out, I was on this methadone, and it was not good for me. I was trying to get off. And with methadone, it's not just like they could tamper you down. Like you can be at 50 milligrams, and if you go down to 45 milligrams, you're going to be sick. It's a very slow, gradual process, and it's a horrible drug, and it's horrible that they still prescribe it. I know now that I don't need a MAP program. I don't need a crutch. I've been 165 days sober, and I feel great. My thinking's clear. Everything's better. If I would have not been on the MAP program when I got out of prison, I feel like everything would have been. I would have had a different outcome because I wouldn't have had that monkey on my back. I wouldn't have had that itch to where if I didn't have the methadone, I was going to be sick, or I was just focused. I had to go to the clinic every day, and it sucked. It really, really sucked. And I was trying to get off it. In the halfway house, I tampered down. I was at like 100 milligrams in prison. I worked my way, but before the time I stopped going actually and just using drugs, I was down to like 43, 42 milligrams. But today, I understand what I did was wrong, man. Selling drugs is not a way to live. It's not a way to be a productive member of society. It's not looked upon. I couldn't see you at lunch or go to lunch with someone like you and be like, oh yeah, I'm a drug dealer. That's crazy. It's insane. But in my head, doing it, I thought it was cool or okay to be a big shot and live that life. All those people that I was appeasing or being around, where are they? I don't see them anywhere in here, except my mother, and she didn't want me doing that. Every day she's looking, like, she knew what I was doing without me telling her, looking at me like, are you stupid? What is wrong with you? But my mom loves me, and, you know, she just wants the best for me. And it's all she's ever wanted. She didn't raise me to be this person, and I tell her all the time, she did nothing wrong raising me. I just became a drug addict, and I took it and ran with it. When I do things, I try to do it to the best, or get the most out of it. So if I'm going to be a drug addict, I'm going to be the best drug addict. If I'm going to be sober, I'm going to try to be the best sober person. I try to do the best and do the most with everything I do. And that's my problem. So if I'm using and selling drugs, I try to be the best at doing that. And look at where it got me. In a situation that I'm facing a lot of time now. And today, I don't want to live like this anymore. I sit in jail and I watch these. It's a vicious cycle, same people in and out. I've watched one person come in and out of jail since I've been in there 4 times. And it's like, man, are you serious? Like, if I had the opportunity to get out, you crazy? The reason I didn't bond out is because I do have another pending case in your court. But if I could have, I would have. My plan was to bond out and go to a treatment to try to show the court that I want something different. I'm not opposed. I've been to prison. I'm not trying to just get out of going to prison, Your Honor. That's not what it is by me asking for treatment. I genuinely need help, and I recognize that today. I'm a drug addict. I can openly say that. Something I didn't understand or realize in the past. Like, I am a drug addict to the fullest. Like, it is a problem. It is a disease. It is like AIDS. It is like cancer. It is like diabetes for me. Drugs are a problem, and luckily, to this day, I'm not dead. I've overdosed 20 times. Hospitalized 20 times, in ambulance. I was thinking about it the other day. I've done it 5 times at my mother's house. She's called on Christmas Day, on January 18th. My dad found me one time. I was out for, they had hospitalized me for like 4 or 5 days where I was in a coma. And none of that stopped me because the drugs are cunning, baffling, powerful. It's things that I've learned in the program, man. Like, they say, like, that's the only thing I haven't done and taken seriously is the AA program. I've always done it just to appease the court or to appease. I've done it for everybody else except myself. Today, I want it for myself because this isn't the life I want to live. I'm almost 30 years old, facing several years in prison again, and have nothing to show for the last 10 years except for prison numbers and overdoses and cases. And that's not me as a person. I'm a hard worker. I was working under the table right before I got arrested. I actually had quit shooting up because, well, one, I couldn't really shoot up anymore because my veins were gone, but because I didn't want it, it was taking me hours to do and I was just hurting myself. There's a needle stuck in my arm to this day. A piece of needle this big stuck in my arm. Did that stop me? Did I care? Nope. Kept using. And it's insane to think about. Like, I would brag about things like this, or the fact that I was using this or doing this or having that and that, and I'm sit back now, I look at myself like, how stupid are you? Like, none of that's cool, no girl's gonna want to be with you. Oh, you're a drug dealer, or you're fat. Like, I'm a fentanyl addict, and it's kind of crazy to say that out loud. I know it kills her saying that, but like, it's true, and I need help. Like, I didn't take NeoCap seriously in the past. I didn't take probation seriously because I had no desire to, and none of it, you know, I'll be honest, when I first went to jail, I thought it was cool. I came home like, oh, I'm making little foxies and this and that and this and that. I thought prison, all that was cool. There's nothing cool about being locked up and being around negativity. Like, now I know that, and I've been there before, and you think, oh, well, why haven't you learned from it? Well, they kind of water prison down now, and they make it so it's easy to keep coming back. It's not where it scares you to come back. But at the same time, I've experienced some bad things in there too. And I've had gang members literally drop a bag and say, give me all your stuff. And it's not, if I'm a drug addict, like I didn't do something where I had to be in that environment. I had to throw up my fists and say, no, you're not taking my things. Like, my mom bought me, that's my mom's money that they put in my books. Like, you're probably going to beat me up, but I'm going to hit you once, and that's like, I'm going to fight back for my stuff, and I shouldn't have to be in an environment where I have to do that because I'm going to easily susceptible to be a target. I don't want to have to get down in a gang if I get 3 to 5 or 5 years or whatever, and because they try to recruit, and that's what it. I don't want to have to be in that environment. But I understand what I did was wrong. There's no, I can't take it back. I wish I could. I really wish I could have did differently when I got out of prison. I had every intention, every desire to. I was working a job in the halfway house at Barrio in Cleveland. I was on the MAP program thinking I was doing the right thing. I came home, I had a check, I had money, I thought I was doing good. And then I let my depression, my use just spiral out of control, and it spiraled out of control so fast that I was so caught up in it that before I know it, I'm 120 pounds, strung out, and got pending secret indictments. I knew my case was coming before it was. I knew I was getting. The girl's boyfriend told me that she wore a wire on me, or for this case. I knew it was coming, and there was nothing I could do about it except try to start getting right. I was working prior to coming to jail. I started painting. I was trying to stop selling drugs and do something productive, but I actually had a bed that I called at square one for detox. The weekend before I got arrested on Friday. They were supposed to call me by Monday or Tuesday so I could try to go to detox, because all my friends and people that I was around were all gone. They were either in jail, treatment, or getting sober, and I was only me out there. So if something did happen to me, I probably would have died, because there was going to be no one there to Narcan me or bring me back or call my mom if, Mikey's gone. Nope. So, and none of them are around me now. I'm grateful that my mom still puts money on my books in the jail. Otherwise, I wouldn't have nothing. Okay. Excuse my beard and uncut hair, but I'm not paying $25 for a haircut when the price of commissary in there is so crazy. And right now, well, I know what I did was wrong, Your Honor. I'm not trying to dodge prison, because I'm not at all. And if you do give me that, I would hope that you would give me a lesser amount of time. But genuinely, I'm asking you from my heart. I need help. I need treatment. I don't want to. This is the opportunity. I want the accountability in my life. I need that. I need something that's going to help me get on track. I needed that when I got out of prison, but I just went straight home. If I go to prison again, I don't want to be back in front of you, but the reality of it is, I'll go to prison, do my time, meet a bunch of new horrible people, and I'll probably be back in front of you within a couple of years, shortly after getting out. That's just the unfortunate reality of it. I don't want to become a product of the system, man. I've already got a couple numbers, but I still got a good head on my shoulders. I still got the desire to want to do better and live a different life and become a productive member of society before I'm old and can't do anything. I'm 30 years old and I got almost 8 to 9 years in already with nothing to show for it. I know what I'm doing out there is wrong, but I need help. I need help, and if I get the option, I'm going to do everything I can to, prove the system wrong, pretty much, that I can do it. Like, I'm not opposed to, if you give me 6 more months in jail, NeoCap, outpatient, Lake House. I would like to go to Lake House to get that structure, sobriety, and build a support system in my life, because I've done good in structure before. I've done a treatment facility before, and I've done well. It's just I didn't stick to it, or I had other issues. Like, I'm starting with a clean slate. I have no girlfriend. I have no outside issues, no resentments. I had that in the past. Right now, I'm starting with a clean slate and a good head on my shoulders. And I'm asking you for a chance, man. Give me enough rope to hang myself. If you want 5 AA meetings a week, you want me to pee every day, I will. If I mess up, max me out. I need help, man. Thank you for listening to me.
Thank you, sir. Mr. O'Connor, anything else?
Nothing further, Your Honor.
For the state of Ohio, Ms. Ronick?
Thank you, Your Honor. I don't think anyone is in disagreement that there's absolutely nothing redeeming about the history of the defendant here, both his criminal history and his treatment history. As has been mentioned a few times already, he has 4 prior prison numbers on 8 separate cases. He went for 19 months, and then for 20 months, and then for 14 months, and then for 22 months, and each time he got out and immediately picked up new charges. He has a history of several probation violations, 3 of which were for negative discharges from treatment. He says he wants treatment and he needs help, and I'm sure that he clearly does need help, but he has 14 stints in treatment that probation was able to uncover, and those are both court-ordered and not court-ordered. That includes NeoCap, that includes a lot of IOP through the jail treatment program. In his interview with the probation officer, he does downplay his drug dealing. He was just dealing to support his habit. He makes a comment that at least he wasn't burglarizing and robbing people. And I think what really sums it up is the statements he made shortly after his arrest, in which he is calling Detective Butler a bitch, and he says, what does he think is going to happen? I'll go to prison and then get out and keep selling. It's my fucking job. Excuse my language. I think that sums up exactly what his life has been like since 2014. It appears that these shorter prison stints, these court-ordered treatments, non-court-ordered treatments, probation, all of those options have had 0 effect on the defendant's behavior and conduct. So the state is requesting that the court impose a prison sentence of 5 years. Thank you.
Thank you. This court has reviewed and considered the pre-sentence report and investigation. We've read and reviewed, considered the drug and alcohol evaluation. I've considered the facts and circumstances of each of these offenses, the nature of each of these offenses. I've considered everything that's been said here in court today by Mr. Polinsky himself, his lawyer, the prosecutor, the recommendations from both sides. All of this is considered in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. For the factors in 2912, no factors present indicating it's more or less serious than normal for the conduct involved. But as for the recidivism factors, almost all of these factors are present. Defendant has a very extensive criminal history, both juvenile delinquency adjudications as well as an adult. It started when he was 13 years old, drug charge, 13 years old. And it's just continued on over and over and over into his adult years. He has failed to comply with previously imposed sanctions ordered by courts. He's been on probation multiple times. I mean, he didn't start out with intervention in lieu of conviction when this all started. But he's been on probation, I can't see how many times. And he's violated so many times on probation when he's been given chances. The drug abuse problem that relates to the offense, and he hasn't done anything to address it. He walked out of the last treatment center he was in. I look at the different treatment that was alluded to by the prosecutor, and he's been given an opportunity at treatment at double digits, and he's walked out on over half of them. He downplays the fact that he is a drug dealer, just says he's just selling to support his habit. And that's the only reason he does it. He is a well-known drug dealer in the area. He even acknowledged it to Detective Butler. No factors indicating recidivism is less likely. As for the felony 5s, in the 29-29-13B1, the court finds defendants previously served prison term. He has served 4 prison terms under 8 separate cases. So 4 separate numbers he has, but at least 4 others were run concurrent to other cases. So he's been sent to prison in 8 separate cases. As for count 2, I believe it is, the felony of the 3rd degree, there's a presumption for prison. In order for me to overcome the presumption and impose community control sanctions, I have to find that the factors indicating recidivism are more likely, are outweighed by the factors indicating it's less likely. And there's no factors even present indicating that recidivism is less likely. So the court can't make the requisite findings to overcome the presumption for prison. Prison is consistent with the purposes and principles of sentencing. There's just no way this court, based on the history, can make the finding that the defendant's amenable to community control sanctions. Therefore, it will be the sentence of this court. And on count 1, defendant served a term in prison of 11 months. On count 2, he served a term in prison of 36 months. On count 3, he served a term in prison of 11 months. And on the lesser included offense of count 4, he served a term in prison of 11 months. Those terms will be concurrent with each other for an overall prison term of 36 months. He has credit for 165 days he's already served. I'll order the forfeiture of the contraband and instrumentalities set forth in count 4, I believe it is. I need to advise you upon your release from prison, you may be placed on post-release control for 2 years. If you are and you're violating those conditions, the parole authority can return you to prison. As punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court will dismiss count 5 at this time. I will also impose the mandatory fine on count 2 of the minimum mandatory fine of $5,000. Defendants also order the penalty court costs and supervision fees. I think that covers everything. Ms. Ronick, is there anything else for the record?
I apologize, Your Honor. What was the fine that you imposed?
$5,000.
The minimum? Okay, thank you.
Minimum mandatory $5,000.
Nothing further, Your Honor. Thank you.
Mr. O'Connor, anything else for the record?
Your Honor, there was one thing I did want to ask. I meant to talk to the prosecutor about this, I think previously. His phone was seized on this matter. Now that the case is concluded, we wanted to see if the phone could be released to Mother, since I don't think it has any bearings on the other case. That's pending.
Is it in the forfeiture?
The cell phone,
Is it
if
in
you
the
remember at the change of plea I mentioned.
Is it in the forfeiture?
Cell phone is not a part of the forfeiture specification. And I can't sit up here and say I remember the specifics, but there was some conversation about that.
Yeah.
Yeah,
If it's no longer needed for the other case, it should be, and it's no longer obviously needed for this case is concluded, it should be released.
Yeah, I will reach out to the Mentor Police Department.
Okay.
Mr. O'Connor, anything else?
What was the last
The
one?
restitution, like, so
Oh,
like
for your
a
costs.
reduced having to pay while I'm in prison. So
Hang on a
take
second,
all
let
my
me turn
money.
your mic off there if you want to talk with your client. I can figure out how to do that.
Your Honor,
All
I
right,
think
go
he
ahead.
was just asking to address as far as for any costs, as far as reduced, so if it comes off of his commissary.
Well, I'm imposing costs.
Yeah.
Court costs are imposed.
Thank you, Your Honor.
Now, we are present in two separate cases this afternoon. Case 25 CR 1066 and 25 CR 226, both cases hang on one second. All right, again, both cases are set for a pre-trial here this afternoon. Defendant is here in court. She's with her attorney, Miss Culotta. Before we get to the pre-trial, I want to address a matter with the defendant. Ms. Watts, you sent me a letter recently requesting that a new lawyer be appointed for you. So I'll let you be heard on that request at this time.
I was just requesting a new attorney just because I felt like there has been a lot of court appearances that I've had to have where I'm only finding out 2 to 3 days before. I know there was a hearing before where she called me and stated we were supposed to be in court that day, and she didn't have a notification also, I guess, of the hearing, and I didn't know of the hearing.
Well, that wasn't her fault.
No.
That was our fault.
So it's just a lot of the court hearings, and then when
Well, there hasn't been any other court hearing. Maybe
well, I
we
mean,
did.
me having to go to like arraignment, I went to an arraignment, and I get there and I find out there's a warrant out for my arrest, and they took me to Mentor Police. I just figured my attorney would know about that also. I'm just,
Why would she know about? Does she represent you in that?
yes,
In the Mentor case?
yes.
She would know that.
She's for those both cases, yes, because she told me about the arraignment at Lake County, and I showed up to that hearing. And
Well, go ahead. I'm interrupting you. Go on, continue.
and I just, it's like, I don't know, I just feel like she's not or wasn't trying to do that much to help me with my case. And just finding out about the court appearances like 2 to 3 days before the hearing or the arraignments that I had to go to. And also, like back in March, I think she was meeting with the prosecutor, or either they were going to the facility enterprise to listen to phone records. I don't know about that. I just feel like I'm kind of in the dark about a lot of things. But she did recently offer that we can sit down and meet face to face in her office and discuss a lot of everything that's going on that we haven't done yet.
So are you?
I'm willing to do that.
So you're withdrawing this request then?
I did want to have that other public defender if I could.
Well, you can't pick and choose which attorney you want, or which. I mean, you're entitled to have an attorney appointed for you. One has been appointed for you, and a good lawyer has been appointed for you. And you're not allowed. You don't have a right to pick and choose which particular lawyer you want. So. I'm not going to order that the public defender's office put Jim Matthews on your case and remove Ms. Tomaszek.
Well, it didn't have to be him in particular. I just put his name on there because I heard about him before. It could have been any.
Again, it doesn't matter. The point is, you don't have a right to pick and choose which particular attorney that you want. You have a right to have a lawyer appointed for you. We've done that, and you have a good lawyer. These cases they may not be brand new in the sense, I know there were proceedings earlier in the municipal courts, but they're pretty new right here for these courts. It's just starting here. And this pretrial is the first time that we get together, and then after that you meet with your lawyer and go over things and decide how you want to proceed. So you don't have to withdraw the request, but I am going to deny that request at this time. Nothing that's been presented warrants the removal of Ms. Tomazik from this case. So Ms. Bell, can you tell me what each of these two cases are about?
Certainly, Your Honor. Starting with the 25CR226 case number, Ms. Watts got a rental car from Enterprise Rent-A-Car in Menor. I believe she started in one vehicle, then switched to another vehicle, and then retained that vehicle beyond the time of her lease. The company tried to contact her to retrieve that vehicle, was not able to, and the vehicle was eventually found in a parking lot, I believe, in Cleveland. And on the second...
So that's the unauthorized use and the receiving?
Yes.
Okay.
And then on the second case number, that's a aggravated possession of drugs and then a possession of dangerous drugs. Ms. Watts had a warrant from her arrest, I think stemming from that first case that we just discussed. She was picked up on that warrant, and in her purse, suspected methamphetamine and then dexamethasone, a dangerous drug, was found in her purse. And that was on February 11th, 2025.
Does the state have any offers that they're going to present at this time for either of these cases?
Yes, Your Honor. The state would extend an offer to plead to count one in the 25CR226.
That's the unauthorized use?
That's the unauthorized use, felony of the 5th degree. And then also to count one in the second case number, the 1066, that being aggravated possession of drugs, a felony of the 5th degree with a forfeiture specification.
What kind of history, if any, does this defendant have?
Off the top of my head, it's a limited history. This, I think, is her first. These are her first offenses that I'm aware of.
Okay, thank you. Is that offer just being made today for the first time?
Yes, I
Okay.
sent it earlier in an email, and we had discussed before the second case came through. It was the same offer on that first case to count one.
All right, so Ms. Tomazik, you received the offer. Obviously, you need to sit down and discuss that with your client, I assume, correct?
Yes, that's correct, Your Honor.
You received discovery in the matter?
Yes, I've received full discovery on both cases.
Okay. And does it appear there's any suppression issues or anything that would require an evidentiary hearing that we need to address prior to a trial date?
No, Your Honor, I do not see any suppression issues.
Okay. Anything else you care to discuss at this time?
Not at this time, Your
All
Honor.
right. All right. So, Ms. Watts, the purpose of the pretrial is for me to get together with the lawyers and the defendant and basically find out what the case is about. It's a new case for me. I don't know anything about what the allegations are. And there are allegations, I get that, but it gives me an idea what the charges are. I also find out whether there's any issues that I need to get involved with in terms of intervening in or that will require my attention. It doesn't appear there are. So what happens next is that you will meet with your lawyer and determine how you want to proceed in this matter. The state extended an offer in both cases in an attempt to resolve these cases. Your lawyer will discuss that with you, and then you'll have to make a decision whether you want to accept that offer or whether you want to go to trial. Now, in regards to that, right now, your trials are scheduled for October 21st and October 28th. The case involving the car is the first one. That's October 21st. And you'll get these dates from Ms. Tomazik. And the drug case is October 28th. In each of these cases, you've been released on an owner cognizance bond, which means you didn't have to post any money. You just signed a form. Your signature was your bond. But what that means when you're released on an own recognizance bond is that you have to appear at all future court dates. And if you fail to do that, that's a separate felony in and of itself that you can be prosecuted for in addition to whatever the charges you're currently charged with. So it's obviously important you show up at all future court dates. So again, in the case involving the car, your next court date is October 21st. And in the other case, it's October 28th, a week later. Now, if there are going to be trials, that will be the date for that I just told you. If it's going to be a plea, if you're going to work some type of agreement out between the prosecutor and you, the hearing to come to court to plead to those charges will be before October 21st. I do it beforehand. I need to know 2 weeks before that October 21st date. So what's that? October 7th. I will need to know whether you're accepting the state's offer or not. If you are, then we'll schedule a date for you to come back to court and enter your pleas. If you're not, then you need to be here in the trial dates. All right. So I guess the point I want to stress is right now the only date I can set is a trial date because I don't know what your intentions are. You may not know what your intentions are at this point. I'm not asking that because you need to, again, meet with Ms. Tomaszek. But we will need to know in the next by October 7th, whether you want to go to trial or not. And if you don't, and you work it out somehow, then the hearing will be before October 21st. So then you need to make sure, if you don't hear from your lawyer as to when that is, then you need to reach out to her. You can call the court if you want. It's your responsibility to know when that court date is. And they'll let you know, but if you're not hearing anything for whatever reason, then make the effort to find that out, because it'll be before the 21st then, all right? Okay. Any questions for me?
No.
All right. Ms. Tomaszek, anything for the record?
Not at this time, Your Honor. Thank you.
And Ms. Bell?
Nothing further, Honor. Thank you.
All right, thank you all.
All rise.